Do state laws that discriminate against arbitration agreements violate the Federal Arbitration Act? We'll explore that question in Kindred Nursing Centers v. Clark. Olive Clark executed a power of attorney designating her daughter, Janis, as Olive's representative. Joe Wellner executed a power of attorney designating his wife, Beverly, as Joe's representative. Janis and Beverly then placed Olive and Joe, whom we'll collectively refer to as the residents, in a Kindred Nursing Centers facility. Janis and Beverly executed all necessary paperwork using their powers of attorney. Both signed contracts, agreeing to resolve any disputes regarding the residents' care through arbitration. Both residents died while at Kindred. Janis and Beverly filed individual suits against Kindred in Kentucky State Court. Kindred moved to dismiss, arguing that the arbitration agreements barred the lawsuits. The trial courts denied Kindred's motions. The Court of Appeals affirmed. Kindred appealed to the Kentucky Supreme Court, which consolidated Janis's and Beverly's cases. The court found that the Wellner power of attorney wasn't broad enough to authorize Beverly to enter into arbitration agreements on Joe's behalf. The court found that the Clark power of attorney, which authorized Janis to handle all matters affecting Olive, was broad enough to authorize Janis to enter into arbitration agreements on Olive's behalf. Kentucky's Constitution provides, however, that the right to a jury trial is sacred. The Kentucky Supreme Court therefore reasoned that representatives may not waive their principal's right to a jury trial unless the relevant powers of attorney expressly grant the representatives that power. The court referred to this rule as the clear statement rule, and here neither power of attorney expressly granted the representatives the right to waive their principal's right to a jury trial. Accordingly, the Kentucky Supreme Court affirmed the lower court's decisions. The United States Supreme Court granted cert.